authenticate.
But also I can confirm that it is even the physical file. This document, the physical file. So that my learned friends do not have it, or that they are shocked that the Chief Justice is not in the country, should be a point for response. They can respond and say, we saw the Chief Justice around. That's a possible defense. My Lord, if I may raise into my time, they will have time to respond. Yes, the judicial report. I can proceed.
My lady, I asked a specific question. We want to know in which case file in the portal, because that's the submission my colleague has made, there's this internal memo. First, I want to know the internal memos are normally in the portal. I'll be glad to learn. But more importantly, in which case file is this internal memo so that we can authenticate? That's simple. My colleague Dan will say it is in the portal. He has a duty to furnish us with the particulars.
We have indicated, my lords, that it is in the physical file. My life friend Mr. Nyamodi will specifically address it so that I can proceed.
Your Chief, would you kindly give us a ruling on our objection?
Please, the applicants, when you are submitting, the respondents gave you time. Please just give them time to make their submissions. You are going to respond. There will be time for you to make a recommendation.
My lord, the proceedings before you are in the public interest. They are in the public interest, and therefore the question of time management, my lords, and the need for expeditious disposal of the application before you cannot be overstated. My lords and relationships, time and again, my friends have submitted that whereas this court can sit at odd hours where it receives an application, that in matters as mundane as the current matter before you, that this court should have had this matter in the course of the day. Because no doubt, my lord, this court has moved to the electronic age where matters are transmitted through mail and through other forms. My lord, but most fundamentally, we are here to challenge ex parte orders, not inter parte orders, not orders given inter partes. And my friends therefore cannot speak from both sides of the mouth that where you are dealing with matters of the impeachment of the deputy president, such as this, that ex parte orders cannot be issued, yet they obtained ex parte orders that necessitated the filing of the application before you. My lord, what we're dealing with here is a removal under Article 145, and which the law defines as final under Article 145(7) of the Constitution. When therefore my friends submit about the office of the Deputy President, they seem to forget that Article 145(7) refers to the finality of the Act of Senate. And therefore, all the orders obtained under the subject, all the orders obtained under the subject of this proceeding were obtained after the impeachment proceedings, after the act of impeachment. And it is therefore important, my lord, in the interest of all of us, that these matters are resolved expeditiously and timelessly, so that this court can move to the next phase. The next phase, my lord, would be dealing with the question of the next step. My lords and relatives, it is clear that my friends do not want to proceed that phase. And that is we have all these multiple applications and the inability of the applicants to want to be confined to the question of time. They want to speak throughout the night. On our part, we want to sanitize this proceeding, my lord, and stick to the point that the application does not meet the threshold set out for recusal, because recusal is also a prayer. They have advanced no reason at all to want this court to recuse itself or to find that it was not empaneled in line with Article 161, 163, 52A of the Judicial Act. You find, my lords, that this bench was properly constituted by the Deputy Chief Justice, exercising powers donated to her by the Chief Justice, unless they're saying that there's another Chief Justice. Thank you.
My lord, my ladies, as a follow-on to the submission by my two learned senior colleagues, I wish to respond further to the application as follows. There has been a lot of water under the bridge since we convened, or since this court convened at about 11:15 or 11:30 this morning. But as I am no doubt members of the court will be able to quickly figure out, the single issue that is before you is a challenge as to the regularity of this, of the referral of the 3 or 4 matters to this bench by the Honorable the Deputy Chief Justice, the Deputy Chief Justice of the Republic of Kenya. And I wish to commence my response to that objection by saying as follows. The Chief Justice occupies 3 distinct constitutional offices. 3 separate and distinct constitutional offices. First, the Chief Justice, by dint of Article 161, Sub-Article 2A of the Constitution of this Republic, is the head of the judiciary. By dint of Article 163(1), the Chief Justice is the President of the Supreme Court. And by dint of Article 248, Sub-Article 2E, the Chief Justice is the chairperson of a constitutional commission established under Chapter 15 called the Judicial Service Commission. Members of the court, I wish to take just a moment to demonstrate how the Chief Justice is deputized in these 3 distinct constitutional offices. In respect of her capacity as the President of the Supreme Court, Article 163, Sub-Article 1B is clear that the Chief Justice shall be the President of the Supreme Court, A, and that B, the Deputy Chief Justice shall deputize for the Chief Justice and shall be the Vice President of the Court. That is the first constitutional office. The second constitutional office is the head of the judiciary, and I will come back to Article 161 in a moment. Suffice it to say that it is in Article 161, Sub-Article 2, that the office of the Chief Justice is established. And Article 161, Sub-Article 2 states as follows: there is established the office of the Chief Justice, who shall be the head of the judiciary. I will come back substantively to 2B in a moment. But it is important that for the purposes of the commission established under Article 248, Sub-Article 2E, the Deputy Chief Justice is then not the Vice Chairperson of that commission. In the Judicial Service Commission, the DCJ does not deputize the Chief Justice. Now, it is our position for the respondents that the 1 Sub-Article 2A, that is not the President of the Supreme Court, that is not the chairperson of the Judicial Service Commission, but that function is exercised by the Chief Justice in her capacity as the head of the judiciary. It is our submission that therefore the Deputy Chief Justice, who is the Deputy Head of the Judiciary, by dint of Article 161, Sub-Article 2B, can exercise the function of the Chief Justice as Deputy Head of the Judiciary. And members of the court, Article 161, Sub-Article 2 creates 3 positions: the Chief Justice, the Deputy Chief Justice, And at sabbatical C, it creates the office of the Chief Registrar of the Judiciary. Now, the Chief Registrar of the Judiciary doesn't deputize the Deputy Chief Justice. But the Deputy Chief Justice deputizes the Chief Justice. That does not require any interpretation. That is really comprehension as a matter of English. It is then for the Deputy Chief Justice, in instances where the Chief Justice is unable to act as the head of the judiciary, the Deputy Chief Justice can then perform that function. Members of the court, I submit that the decision in Lina Conchela is good law. And the facts in Lina Conchela are important. When you retire to consider your decision in this matter, you will note that the only respondent in Lina Conchela was the Chief Justice. The only respondent in Lina Conchela was the Chief Justice. If, for the sake of argument, we go along with the submissions made by our learned colleagues for the applicants this evening, that the Deputy Chief Justice then cannot deputize for the Chief Justice, then in Lina Conchela, when a judge of the High Court certified that the issue in that matter was one fit and proper for an expanded bench under Article 165.4, then going by the argument, then there would be nobody to empanel the bench because the Chief Justice was a party. How can he or she empanel a bench in a party where there are respondents? That is the absurdity in the argument by the other side. And my lord, it is our submission, or it is our position, that the constitution of this republic must remain elegant, and it must remain functional. Interpretations such as the one urged by my learned colleagues for the applicants, that would lead to that sort of an absurdity, should be rejected by the court. It is my position, as I am on my feet this evening, as I have been consistent, that the Constitution says what it says. But the Constitution only means what the courts of law in the Republic of Kenya interpret it to mean. And it is the interpretation of the Constitution that gives it life, that gives it meaning. And my lord, my lady, it is therefore my submission that it is a proper interpretation of the Constitution, flowing from the express provisions of Article 161, sub-article 2 down, that as you sit as the three judges presiding over this matter this evening, you have no doubt as to the regularity of your environment. Because if you did, and flowing from the accolades that have been heaped upon you by learned counsel for the applicant, then you would not touch this file. There are other files that are equally urgent, that deal with the same issue, that have been brought to your attention this morning, this afternoon, and maybe again this evening, where you have said, in the absence of that direction, under Article 165, sub-article 4, you are unable to deal with those matters. So, my lord, my ladies, being satisfied, or you being satisfied with the regularity of your empanelment, this application is for dismissal. And I must add, with cost. So that the important substance in this matter can be determined by the court. I'm most obliged.
My lords, my ladies, permit me to just conclude with giving a bit of a context in the Conchela matter. I'm not going to explaining anything because, my lords and my ladies, the decision speaks for itself. The decision is a decision of 5 judges of the High Court. In particular, my lords and my ladies, paragraph 97 is instructive. 97B in particular if I may, reads that the exercise of powers under Article 165(4) of the Constitution, though constitutionally underpinned, is administrative in nature. They go on to add that being administrative in nature, the said mandate can be exercised by the Deputy Chief Justice when the Chief Justice is absent, when necessary, or if for good reason the Chief Justice is unable to exercise the mandate. At D, they conclude that in the present circumstances, the rule against bias and the rule that no person shall be adjudged in their own cause dictates that the Chief Justice, being the main respondent in the instance petition, could not assign judges to hear the petition. My lords and my lady, that is the absurdity that learned senior counsel, Professor Gidu Wigai, was talking about. Take it a step further. Is it therefore their case that if, as contemplated by their lordships in that matter, if for one reason or the other, the Honorable Chief Justice is unable to perform the functions of that office, is it therefore their case that no matter that requires constitution of a bench will be heard or determined? That certainly would be an absurdity that the law would not have contemplated. That said, my lords and my lady, one of the things that will play out by close of business these submissions is that our learned friends from the other side have very deliberately taken to concealing what would otherwise be material information before this court. I say that for two primary reasons. I want my lords and my lady to make reference to their own application, to the grounds supporting the application. They start, the application is based on the affidavit of Honorable David Muja Matenge and other grounds. The other grounds include A, that on the 18th of October 2024, the petitioners herein filed the instant petition together with an application under certificate of urgency seeking conservatory orders restraining the assumption of office by the second interested party pending the hearing and determination of the application and petition. They go on to say that on the same day, the matter was placed before the Honorable Justice Mongo, who considered the matter, and in light of the urgency of the matter and the weighty constitutional issues raised, the Honorable Judge issued the conservatory orders sought in the first instance and certified the matter as raising weighty constitutional issues and referred the matter to the Honorable Chief Justice to constitute a bench to hear and determine the petition. This is where now the story starts. That on the next day, being Saturday, 19th October 2024, the petitioners were surprised by the turn of events wherein they were served with the order of this Honorable Bench stating that the first and second respondents' applications dated the 18th October 2024, in bracket the applications for were to be had for their inter partes hearing on the 22nd of 2024. Why do I say there is deliberate concealment of material facts? It is because, my lords, looking at the files that were coming up before this court today, that is E565 of 2024 before the court in Nairobi, and E015 of 2024 in Kerongoya. We immediately, upon learning of the orders that had been issued and which have been adverted to here, filed an application. It is on record. That application, my lords and my lady, sought several